Recording in progress. Okay, so again, thank you for joining us. We did send the handouts out yesterday. Today we have our subject matter expert on all things that we just love to cover. And it's Patty Eyres, our attorney at law, is joining us for tackling the top 5 employment law landmines at the start of a new fiscal year. I know from just talking to a few of you that there has been a lot of movement and a lot of people taking new positions, and there's still a lot of hiring going on. So this is very timely. It does feel weird to not be having a COVID-centered topic, but we will be covering that on the next session that Patty is joining us for on August 10th. There are a lot of hot buttons right now about the masks and vaccination and testing and that sort of thing. And we'll be watching for those announcements and always sharing what we have with you. And you can always reach out to us in the meantime, but we'll be getting a presentation together for that in the coming weeks. And of course, we have a regular Tuesday weekly meeting, which is a great place for all of us to come and collaborate and see what we're dealing with and hear how everybody is handling things. So next week, we will have our regularly scheduled risk managers update meeting. We did send out the handouts yesterday, and we do have that, like I said, if we have questions, go ahead and put them into the chat and we'll field them as they come in. So again, thank you so much, Patty, for being such an awesome resource for us and always clearing the clouds, because we need so much clarity on all of this. And it is a bit, overcast at times. So we appreciate that, and I will hand it off to you.
Okay, well, thank you very much, Jennifer, and welcome everyone. As Jennifer said, we are not going to discuss much about COVID today, almost nothing, as a matter of fact. Now, I know those of you who are eagerly watching the news every day, you know that the CDC issued a new guidance this morning, and we're expecting CDPH to follow suit with mask mandates in some places for fully vaccinated people. So there's going to be a return to that. CDC did confirm today that they are of the view that K-12 schools, everyone should be masked regardless of vaccination status. So we know you're following that. Be assured that we're following it as well. But today we have a different topic for you. We thought we would take a break from COVID as much as we possibly can and focus on some other things that have not gone away just because COVID has kind of taken front and center for us. So today we're going to tackle the top 5 employment law landmines at the start of the fiscal year. We'll look at some strategies to prepare your school districts and county offices. And so we're going to look at first, what are the top 5 risks that are facing you or that your districts and your county offices are facing. You may not be surprised to see that there's a lot of overlap between those and things that we talk about on a daily basis or regularly, which involves accommodations and leaves and other kinds of processes. So we'll look at that. We'll look at establishing and enforcing effective processes, because almost all of the risks are process driven. It's a lapse of process rather than a lapse of intent or an affirmative intent to discriminate or harass or treat people differently or deprive them of their rights. Rarely do we have people who are intentionally violating the law. What happens is we have lapses in process, and the processes are legally required. So you have heard me, if you've attended sessions with me before, you have heard me say that you'll often hear lawyers and HR professionals, and maybe even you yourself have communicated this to your teams, the mantra of document, document, document. If you don't document it, it didn't happen. Well, that's true, but my mantra is process, 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 and then be sure to document your process. So we're going to look at the process-driven risks and help you to pay attention to prevention with practical protocols for keeping your public entity managing and educating and not litigating. So that's our focus today. So what are the top 5 explosive liability risks? And as always, I should say that I have given you handout materials that are appetizer to dessert. They are, Jennifer sent them out yesterday. If you didn't get them, you can contact SIA, Jennifer, or you can contact me. We'll make sure you get them. We've given you several different handouts this time. We've got the PowerPoint slides, and then we have 2 or 3 different checklists. One is retaliation and leave law, one is disability and leave law, that are checklists for you and your managers and supervisors. We're not going to cover those in depth today. That would take us a whole day. I used to use them in live training when there was such a thing as live workshop training. So I'm going to focus on the 5 top explosive liability risks today and how people can stumble into trouble and blow up even the best defense, even the proper decisions that you make can blow up in the courtroom with stepping on a landmine that nobody anticipated. So the top 5 are, as I said, process driven. The first one is workplace accommodation processes. And before you roll your eyes and say, oh, I don't really have to attend this, I've attended Patty and other people's workshops and training on how to do the interactive process. I am making the assumption that you have either attended the programs that I have done recently for SIA and STSIG on conducting the interactive process, documenting the interactive process, triggering the interactive process. We're going to proceed today with the assumption that we're past the interactive process, that we are, not that we're past it in our workplaces, that we're past it for today's discussion. And the focus that we're going to have today is on, okay, what happens after your HR and your risk management people have done a brilliant job with your interactive processes, and you have made decisions and you have made the decision to implement a reasonable accommodation. You've approved an accommodation or an accommodation plan. We're going to pick up today, just for the purposes of today, with implementing the accommodation process that has its own set of risks if it's not done continuously and on a regular basis. Not just the continuous interactive process, but the continuing monitoring of implemented accommodations to make sure that they're working, to make sure that if they're not working, we evaluate why. This can be temporary light duty, or it can be long-term accommodations, both industrial and more often non-industrial. So we're going to focus on those with a passing reference to COVID, but we're going to focus mainly on the kinds of things that we have seen in the traditional interactive process before and that we expect to see again. So that's number 1 risk. Number 2 risk is, and these are not in any particular order, by the way, everybody's work site and everybody's school district is different. Our number 2 risk of absence management processes may be your number 1 risk in your particular district or county office. So we're going to look at absence management processes, again, not from the standpoint of, the employee makes a request for leave, we determine eligibility, we determine what kind of a designation letter we're going to do. We're picking up sort of in the middle, assuming that we've done all that prep work for managing leaves and determining what gets stacked and what gets tracked and what is concurrent and what is consecutive. And we're going to look at managing those leaves once they have been approved and when you find, if you find that there may have been some leave misuse or fraudulent leave. So we're going to look at 2 specific things in the absence management process in the time we have together today. One is on avoiding leave interference claims, which is a very real concern at all stages of the absence management process. And then if we're not looking at leave interference claims, we're looking at how to determine what to do when you have a frontline leader or somebody in HR who says, we think this leave is fraudulent. We've seen indicators that the employee fabricated or exaggerated their right to leave, and now we want to pull the leave. Well, we want to evaluate whether the leave whether there's misuse and whether there's, I don't like to use the word fraud lightly because that's a significant standard of proof, but is there exaggeration or fabrication that led to leave misuse? And definitely we want to look at that. We want to do that in a process-driven way, not jumping to a conclusion and pulling the leave and ending up with a leave interference claim. So we'll look at absence management processes, work climate processes. We won't spend a lot of time on what's harassment and what's bullying and what's abusive conduct. We've covered it before. We surely will cover it again, if not in the context of COVID with mask and vaccine proponents and opponents, but just the regular run-of-the-mill harassment and bullying. People are, lots of people who have been affected negatively by COVID and the shutdown and the uncertainties and all those things. They are coming to work to some extent angry and upset and lashing out at things that they would not have prior to 2020. So we're going to look a little bit at that, mostly at the area of investigation process integrity. And then number four, our number four high risk is investigations themselves. Now take a look at this. We don't have much in the way of investigations with workplace accommodations other than if somebody claims they were retaliated against because they requested an accommodation and there was a reprisal. Where we see the investigation process overlapping, it's its own thing. It's its own legal liability and legal responsibility. But in addition to that, if we have the potential for fraud or misuse, we've got to investigate it. It's a misconduct investigation. If we have workplace climate reports or complaints of harassment or bullying, it's a process issue. It's an investigation process issue. So we have overlap with the investigation process. And then, of course, we have what flows from misconduct in absence management, misconduct in workplace climate, misconduct in or lapses in the integrity or the completeness of the investigation. Then we've got disciplinary processes that we have to look at, discipline and due process. Now, this sounds like an awful lot to cover in 90 minutes, and it is. So we're going to take it very quickly and small bites in each of these segments with the understanding that as we get into the new year and we get past the immediacy of having to focus on all things COVID at the very beginning of the year, certainly, we will come back and revisit some of these issues. This is not the end of us talking about leave management process and investigation process and discipline and due process. In fact, we may be talking about discipline and due process 2 weeks from now when we're talking about disciplining, people who are unwilling to follow directives to wear face coverings and tell the truth on their vaccine attestation. So we'll address some of these issues in other contexts as well. But let's talk for a minute about when we distill down the 5 processes that were on the prior slide, where do we see the biggest risks? Implementing approved accommodations. We have resistant supervisors. We have gripes by coworkers, and supervisors have to get a grip on those gripes. We have challenges in implementing them because of the press of business, because of all the things that the foreseeable and unforeseeable things that happen in the workplace that may impact an accommodation that is in process. What do? Do we throw up our hands and say, well, we tried and it didn't work, so now we're going to put the person on the 39-month reemployment list? No. We look at what can we do in our process to determine how we can effectively implement these workplace accommodations, or if they are no longer working and there's a reason to make a change, how do we do that? Then we have expanded leaves of absence. I'm going to touch on, but I'm not going to spend a lot of time in my words, but on your screen and in your handouts, you will see a reminder of what the new CFRA leave requirements are, particularly for caregiver leave that's been extended to grandparents, grandchild, sibling, and other things. And then we will look at traps that lead to leave interference claims. The things people say, not meaning to violate the law, but nevertheless potentially violating the law. Dealing with leave abuse, it's a big issue. We have a lot of concerns about it. We'll talk about it without pains and without lawsuits. Misconduct for lawful, that you determine through a lawful investigation. We do still have liability for harassment and bullying. We can't get away from that. And discipline and due process, we'll look at some of the traps for the unwary. So this is our focus today. So each one of our segments, we have a cover slide for them with the top risk number. And again, I've labeled these 1 through 5. I don't think these are necessarily always going to be the exact order that you're going to find in your districts, and that's okay. Here we're talking about implementing processes. So we are picking up, we're not talking about the interactive process, that's done. We're not talking about the decision as to whether we make or don't make a reasonable accommodation, that's done. We're starting from the premise that we've done an interactive process, that we found a reasonable accommodation, that we have approved that accommodation, and now it's in the implementation stage. So what are the recurring risks in that context? Well, first of all, there's a failure to recognize that the interactive process is a continuous duty whenever circumstances change, and that's the case with COVID and non-COVID situations, particularly COVID long haul, where the individual's work restrictions change. So even though we've had an interactive process and we've approved an accommodation, we might need to amend or extend an accommodation in a way that is different from what was originally approved. That requires a further discussion, which is part of a continuous duty that we have. Let me give you a case example. We don't have a lot of time in 90 minutes to talk about a lot of cases, but there is one case that was of particular interest to us. It involved not a school district, it involved Albertsons Market, and it was from several years ago, but it hasn't been overturned, so it's still good law. What happened in that case is that there was an employee who was a checker, at the checkout stands in the grocery store, and she had a physical condition that required her, that made it so that when she had to use the restroom quickly, she really had to use it quickly. This was like, when you gotta go, you gotta go. And so she had an accommodation that was approved that would allow, she had to drink a lot of water for her thyroid condition, and this made her have to go to the bathroom more. And so she would have to take more bathroom breaks during the day. That was approved. It was approved by HR. It was approved by risk management. It was also approved by the store manager where she worked. Then what happened? Well, that store manager either got promoted or went on to a different job. A new store manager came along who wasn't all that excited about all these bathroom breaks and told this woman, this employee, that she couldn't take her bathroom breaks. And she said, but it's approved as an accommodation. And the new manager said, well, I don't care. I'm the new boss, and you're going to have to just wait until your regular break. At which point, the poor employee had an accident, was terribly embarrassed because she had an accident because she couldn't go to the bathroom. And a jury trial was not amused, jurors were not amused, the appellate court was not amused, and they said, once you put an accommodation in place, it stays in place until someone through a process makes a deliberate decision to change it. For good and legitimate reasons. Either it's not working or the restrictions have changed or whatever. Here, the lapse in their implementation process was in the transition from one manager to another manager. We'll give the second manager credit that she wouldn't have behaved that way had she known about it, but it was Albertsons, the employer's responsibility. So we need to recognize that it's a continuous duty. Once it's been implemented, once we've made that decision, we can't just willy-nilly change it unless we go back to the drawing board. So failure to recognize triggers for the continuous interactive process, uncertainty about accommodating temporary restrictions. How long do we have to accommodate them? Is it different for early return to work programs for workers' comp than it is for non-workers' comp? Then we have commentary about modified schedule or other accommodations for chronic medical conditions. We've implemented it, and then we have a lot of sniping and griping going on, not just from coworkers, but from supervisors as well. The sniping and griping has to stop when it's an implemented accommodation, and that's where we have traps for the unwary. We can't go back and say, well, we did it, and we did a beautiful, timely, good faith, individualized, interactive process. We win. Well, no, because there's still more process. Okay, we did a timely, good faith, individualized, interactive process. We implemented an accommodation. We win. No, because you have a continuous process all the way through, even after you have done what HR and risk management are most focused on, which is the beginning. So we have to have a beginning, a middle, and an end. And today we're looking at the middle and the end, and we find that we can sometimes have lapses that create the same liability and the same problems in the courtroom as if we had never done an interactive process at all. Failure to get gripes by coworkers, you got to get a grip on those gripes. Forcing employees to take leave prematurely when accommodations are available. This is particularly a concern when we are accommodating people with chronic health conditions. I told you the word COVID would not cross my lips today, but I have to point out that with COVID long haul, we're going to have a lot of these where we have people who have who have had an accommodation approved, a modified schedule accommodation, and the frontline leader and coworkers are not happy about it, so they say, well, we've got to pull that and put them on leave. No, leave is a last resort. If we're going to change the accommodation that has been approved and is in the process of implementation, we have to do it with another interactive process or a continuous interactive process. Expressing a significant concern about creating a precedent. Gee, this is going on for a long time, it's going to create a precedent. No, it never creates a precedent. That's if you have done a timely, good faith, individualized process, you've implemented something on an individualized basis, it doesn't create a precedent for anybody else. That's legally sound. Reluctance to address performance problems or monitor, well, that's the opposite approach. Sometimes we have supervisors who want to, change the implementation and get the employee out of the workplace. Sometimes we have supervisors who don't want to address performance problems because they're afraid they're going to be accused of retaliation. They're afraid they're going to be accused of wrongdoing, and therefore they don't do the performance management process. That's equally a problem. Because employees have the right to be successful based on what they do on the job. And if they are reasonably accommodated and we're implementing accommodation, they still have to meet performance standards. That's the expectation. If they don't know that they're not meeting performance standards because that information has not been conveyed to them, it's very hard for them to improve their performance. Perceiving employees as disabled or too limited, resulting in micromanaging of their performance. That's a concern that we always have all the way through the process. So I'm going to take you through some lessons learned from the hotline trenches. I have been doing this hotline work with school districts and other employees for 16 years. We're starting our 16th year with Schools Insurance Group and 15th year with North Bay Schools Insurance Authority. And now we're in our 3rd year with SIA. And we've learned a lot over the years. Let me tell you one thing that is very clear. None of the examples I'm using today are drawn from any of my clients' workplaces, but I have learned a lot of lessons from the hotline trenches on supervisors who wanted to discontinue approved accommodation. One is failure to recognize that the authorized accommodation was based on an individualized process. So then what happens is the supervisors are comparing this employee with another employee or other employees and treating them differently as a result of their approved accommodations. Invoking undue hardship due to concern that employees may either gripe or seek the same accommodation. So that's an outgrowth of the we don't want to create a precedent and we don't want to create gripes. So we're going to not implement and not enforce and supervise the implementation of this accommodation plan. Relying on a snap judgment about safety or hardship, that is always a concern without first engaging or re-engaging in the process. Claiming that an accommodation creates an undue hardship when it involves performing essential job functions in a way that is different. We never, ever, ever have to remove an essential job function to make a reasonable accommodation. That is clear. We wouldn't have implemented it after the interactive process if it wasn't a reasonable accommodation. So when we get to we're implementing this now, the supervisors, they may not like it, but they have to get with the program. This is why one of the things that I say is in your interactive process, it's very important to bring the supervisor along because they're going to have to implement it and they're going to have to follow the law in implementing what HR has authorized them and tasked them to do. And so we want to make sure that they don't depart from established practices and policies in the way that they implement. One of the things we do in an interactive process, I've said this before, is we bring the supervisor in outside the presence of the employee whose accommodation is being considered. And we say to the supervisor, here are some of the things we're considering. What do you think? And we give the supervisor an opportunity to vent and gripe and tell us every single way why it would never work. And it's not a reason, it's undue burden, and it's too expensive. And then we just sit there and we say, why? And we get the supervisor to articulate it to us in objective, factual terms. If we do that, the supervisor has had every opportunity to say why it won't work. And then sometimes we have to tell the supervisor, legally it is required, and here's how we're going to make it work, and here's how we're going to partner with you to make it work. So here's some additional lessons learned from the hotline trenches on attitudes and assumptions about employees being accommodated that can create legal landmines. One is the assumption by supervisors that an employee with a prior injury is more likely to get hurt on the job. And they write these things. You've got supervisors who would never shoot from the lip in talking about an employee's performance or an employee's status, who would never shoot from the hip in making a business decision, but they're shooting regularly from the fingertip and writing things in email they would never, ever say out loud. And those can come back to bite you in the courtroom, even if there was no reasonable accommodation, even if you did a perfect interactive process and a perfect accommodation plan and it didn't work, or there was no reasonable accommodation, you make a decision that's righteous, you want to be able to get that decision upheld, and you don't want these assumptions in word or written email to interfere. So an employee with modified duties likely to get hurt. Disability, this is one of my favorites. Disability laws don't protect people if their own negligence caused them to get hurt on the job. Well, we know that that's not what the workers' comp system says. The workers' comp system says it's a no-fault system. The reasonable accommodation standards say it's not the employee's fault, even if they smoked too much or they drank too much or they ate too much. And some of those habits contributed to some ultimately disabling conditions. We don't raise that because it doesn't get us anywhere, except a frowning set of 12 ordinary people drawn from the community who are sitting in the jury box. They don't like to hear this. Even if they might think it themselves, they don't like to hear it when it has cost somebody their job who are disabled and unable to work. An employee whose own behavior caused them to get hurt or sick is not entitled to workplace accommodations. That's the same kind of outgrowth. Gee, if they'd only stopped smoking. Gee, if they'd only wore a face mask and didn't get COVID. They should have worn a face mask. They should have been vaccinated. That's not going to get us very far. Certainly not in this context. If we have COVID long haul, we're going to seek all the ways to implement accommodations that are appropriate. An employee with a mental disability is always a safety risk and must be kept out of a safety sensitive job. Look how broad that is. Everybody with a mental health disability of any kind or a mood disorder of any kind is always going to be a safety risk all the time, every kind of job, every kind of safety situation. Well, you know, if you look at that in practical terms and you pick it apart, you would say, well, that doesn't make any sense. Jobs are different. People are different. Mood disorders are different. Interactive processes are different. Reasonable accommodation plans are different. Implementation has to be based upon the individualized assessment that we've already made. And of course, employees with disabilities will increase insurance costs. We don't let our supervisors think that. Assumptions and stereotypes about pregnancy. I don't want to spend a lot of time on it, of course, because we're not talking about pregnancy accommodations too much today. But there's always the assumptions that we have to overcome from supervisors. We have to protect supervisors from themselves. We have to protect human beings from themselves. Supervisors wear two hats. One is human being and the other is supervisor. And they can't let the two blend together. So assumptions about, you know, well, we'll have attendance problems. Well, she's always a safety risk because she's pregnant. Accommodations involving light duty are only available for employees who are hurt on the job. That's nonsense under California law. We have to provide accommodations in the same way for pregnant employees that we do light duty for injured workers. A pregnant employee who takes some sick days in early pregnancy must be placed on leave. No, you let them work as long as possible. If they take a few days of leave because they've got morning sickness or other things and can't work, fine, but you don't put them on your PDL leave in the first trimester, or they will exhaust their entire PDL before the baby ever arrives. And they will be able to work later in the pregnancy. So these are the kinds of assumptions that we want to avoid, particularly when we're trying to implement an accommodation that has already been decided upon. Saying things like, well, we can't remove all stressors, so we can deny accommodation for anybody with a high-risk pregnancy. No, we take them by the numbers. And of course, we want to get a grip on gripes by coworkers. They can discuss with their supervisor or HR their concerns about having their own work environments negatively affected, if that's their concern. But the griping and the sniping just has to stop. She's getting a free ride because she has a modified schedule and can come in later. If it's been approved, it's been approved. If it's been approved, it's a reasonable accommodation. So we can't let coworkers get the best of us. There was a case that involved Caltrans with a jury from Nevada County with a $3 million jury verdict 2 years ago. 2.5, well, it was pre-COVID, let's say 2.5 to 3 years ago. And what happened in that case is that the employee had a chemical sensitivity and fragrance sensitivity issues, and he was being accommodated. They had made a decision to reasonably accommodate him. Part of that accommodation, his coworkers didn't like because it involved a scent-free, fragrance-free work environment. And when that happened, then the question was they couldn't wear their own preferred hygiene products, personal hygiene products, and they were mad about it. And so they took it out on the employee, who then was the victim of harassment and retaliation, allegedly, and also failure to reasonably accommodate. Keep in mind, the cause of action for failure to reasonably accommodate is not just failure to make the decision on the front end, failure to follow through and implement the decision on the back end. So that is one of our bigger concerns as our risk number one, is making sure that accommodations that are being approved. HR is working hard. Risk management is working hard now, trying to determine reasonable accommodations for everybody, those that are high risk and immunocompromised, those that have other kinds of non-COVID related conditions. Once we put those in effect, we have to rely upon not just HR to partner or risk to partner with frontline leaders. We have to rely on the frontline leaders to do the right thing and not destroy what would otherwise be a good and righteous defense. So absence management processes. Let me see how I'm doing on time here. Absence management processes. We're looking at out of date or incomplete process or inability to address leave abuse properly. So I've provided you, as I do always in these materials, some checklists that you can use as job aids. These are different from the text checklists that are also part of your handout materials. This is strictly in the PowerPoint handout. These are process risks associated with absence management. Inconsistent leave request process leads to, maybe the result of out-of-date policies, but it leads to not being able to implement the leave on the back end because the request process was flawed in some way and we didn't have the right information. Lapses in process for initial designations and updated notifications. Biggest single issue that we have, that we are concerned about. During COVID, everything was different during the height of the shutdown, and then essential people were coming back for food service and other things. And a lot of leave designations, including parental leave, actually, slipped through the cracks and never got designated. We can live with those process failures because they are unlikely to, we think, to produce long-term negative risk consequences. But what we've got with lapses in processes for designations now is if you don't designate it properly, that time never starts to run. And you may end up with the employee using all of their paid leave. You're ready to put them on the 39-month reemployment list, and oh, well, we didn't designate the FMLA or the CFRA or the PDL or whatever it is. Oops, we have to go back for 12 weeks of at least benefit protected leave, even if they've exhausted all their leave. We have unclear policies about the entity, the school district's 12-month benefit year. What does that mean? The 12-month benefit year is the year that you use to determine. They use 12 weeks of FMLA and CFRA in a 12-month benefit year. You can choose the fiscal year. You can use the calendar year. Almost no public entities use the calendar year. You can use a rolling 12 months rolling forward from the first day of leave, or a rolling 12-month period rolling back. You can use rolling backward or rolling forward. There's 4 different ways that you can choose. Most entities choose either the fiscal year or the rolling forward year. But you need to know what your benefit year is, and your employee who's taking the leave needs to know what it is so that it can be enforced on the back end. Haphazard documentation at the department level is a big concern. Juggling complementary and conflicting statutory requirements is a big concern, and confusion about which 12-month period applies. That's part of the same thing with the benefit year. And mistakes in calculating concurrent and consecutive leaves. Here's what we want you to know about leave interference. Almost any violation, any technical violation, these are technical violations on this slide, technical process violations. Did we approve it? Did we designate it? Did we track it? Did we apply concurrent leave consecutively or concurrent leave properly or consecutive leave properly? Did we apply ed code leaves properly? How did we handle that process? Almost any violation of that process can be leave interference. More importantly, the things we are concerned about with frontline leaders and some HR is refusing to authorize CFRA leave or discouraging an employee from using it. How do supervisors discourage people from using their leave that's been approved? They call them on the phone and they say, when are you coming back? We need you. Well, the employee's on approved leave. Don't do that. Don't call them and say, when are you coming back? The when they're coming back should be in their designation letter or in their leave documentation. Go to HR and ask when they're coming back. That's fine. HR will tell the frontline leader what's expected. Don't call the employee on the phone. Don't call the employee on the phone and say, for example, a father or a second parent who's taken parental leave would sometimes get a call, a well-meaning call from their, supposedly, from their frontline leader that says, hey, how are you doing with your parental leave? Are you bored yet? Are you sleeping okay? Or are you getting up in the middle of the night playing Mr. Mom? Those kinds of comments may be well-intended. They may be intended as a joke. They may not be intended in a negative way, but they could be taken as a negative way. I will tell you that even if the employee doesn't take them in a negative way, if there were to be a complaint for leave interference to the Department of Fair Employment and Housing or 12 ordinary jurors drawn from the community, you can bet that they would look at that as pressure not to take the leave, pressure to delay the leave if it's a parental leave, pressure to come back early, pressure that, you don't seem to be a team player because you're taking all this leave while other people are working. Hey, we're shorthanded here. We've got all this COVID stuff going on. And would be something that would be said by a supervisor. We've got all this stuff going on. We have a hard time getting subs. We really need you to come back. And you're playing Mr. Mom. The fathers and the second parents who are taking their parental leave that they are eligible for are the ones who are most often likely to be treated to that kind of leave interference. Is it intended to say, we're going to pull your leave from you? No. We're going to not let you take your leave? No. It's pressure. It's peer pressure. It's supervisor pressure. It's not retaliation. It's leave interference. What's the difference between leave interference and retaliation? Not much when it comes to damages. Front pay, back pay, emotional distress damages, and attorney's fees. So we want to be careful about that. We don't want to reduce employees' hours to keep them from being eligible for leave. We don't want to terminate it, which doesn't really happen much in public sector, terminate an employee when we anticipate they'll be eligible for CFRA leave. We want to be careful with the CFRA caregiver leaves these days. That's where we see some leave interference. We see supervisors saying things like, can't you get a babysitter for your elderly parent, the equivalent of a babysitter, and come back to work? We're not talking about high-risk exposures here. We're talking about people who have family members who have maybe dementia, parents or grandparents now, or siblings who would be covered. And we have just lack of thoughtfulness in what people say that can be leave interference. Lessons learned from the hotline trenches about attitudes and assumptions that can blow up even the best defense. Employees who take FMLA leave aren't committed. If they were really committed, they wouldn't take 6 weeks or 8 weeks or 12 weeks of a baby bonding leave. Maybe the birth mother, but nobody else would take that if they were really committed. That's not a unheard of reaction. Employees only take extended leave when they know they have a performance problem. We see a lot of supervisors articulating that. The things that come out of the mouths of supervisors and HR or come out of their fingertips on email, which is even worse because it's memorialized, somebody has to overhear the words. Not so with email. Email is discoverable, and all kinds of landmines can be found in email. Employees who are using intermittent leave are a burden to the district and other coworkers must pick up the slack. We see that alleged by both supervisors, or said by both supervisors and coworkers, leave interference. Front pay, back pay, emotional distress, and attorney's fees. An employee on leave for a mental health issue must be committing fraud. I'm going to have more of that in a few minutes. The majority of FMLA leaves involve leave abuse. That's an assumption that people make. These are subjective assumptions. That's what a lot of the lessons we have from the hotline trenches. Subjective assumptions that make their way into words and communications in a way that can come back and bite you at the most inopportune times if there's a claim. The next couple slides I'm going to go through very quickly. This is a reminder of the expansion of CFRA that was effective January 1st of 2021. It expanded to grandparents, grandchildren, sibling, domestic partners, and children of any age. Oh, now, why is that a big deal? Why is children of any age, child of any age of an employee, even if they're not disabled? Why is that a big deal? Because pregnancy is a serious health condition and a disability. And if you have an employee who has an adult daughter who is pregnant and temporarily disabled due to conditions of pregnancy, childbirth, and recovery, that employee can take a caregiver leave for that in ways that they could not take prior to January 1st of 2021. That does not mean that the adult child is incapable of self-care all the time. They don't have to be disabled like they used to be required under CFRA and like they're still required under FMLA. So child of any age can be a child who's pregnant. It can be a child who, went astray on the ski slope and managed to break 2 legs and an arm, and they're temporarily disabled, but they're an adult, but they're an adult child of your employee or an adult grandchild of your employee. These are now caregiver leaves. Expanded definition of family member as an adult over the age of 18 or the child of a domestic partner over the age of 18, even if they are not adopted. So now this is consistent with kin care. The other changes are that both parents can take 12 weeks of job and benefit protected leave for parental leave. You need to be aware of that because they can both take subdifferential now, or 100 days at 50% for the whole 12 weeks. Used to be they had to share it, not anymore. If they're 2 parents of the same child who has arrived in the home by birth, adoption, or foster care, they don't even under California law have to be married to each other. Not only can they be domestic partners who have chosen, although it's legal now for domestic partners to marry, they may have chosen not to for personal reasons, or you may have opposite gender parents who chose not to be married for some reason, but they're both going to parent the child that they acquired by birth, adoption, or foster care, and they both are entitled to 12 weeks if in fact they are co-parenting the same child. So this means that paid parental leave is going to be available for both parents, and we can't interfere with that. We can't interfere with that. Here are the definitions for grandchild, grandparent, parent, parent-in-law, and sibling, which are in the new law. So now let's turn our attention. Now that was a very, and as I said at the outset, we're not going to leave the subject of regular old-fashioned leave management. We will cover it in detail, all the things that don't have anything whatsoever to do with COVID, and we are waiting for the day when we have just the plain old-fashioned leaves that don't have anything to do with COVID issues. We will return and do a whole webinar for you.
Excuse me, Patty, there is
Yes.
a question in the chat. It says,
Okay.
are in-laws such as mother-in-law or father-in-law included under CFRA?
Well, they gave the definition of parent-in-law in the law, so that sort of implies that parent-in-law is subsumed by parent. It's not listed separately. It's a little ambiguous, which is why I put this in here. They gave the definition of parent-in-law right in the law. So we have to look at each of these when it is a parent-in-law. Technically, it's not supposed to be covered, but why would they give you a definition if they weren't going to cover it?
Terrific.
Is the theory.
Thank you.
We're waiting for the implementing regulations to give us some clarity on that. So now let's look at the top 10 thorny issues for leave abuse, because we always get questions about leave abuse, particularly with intermittent leave. So we're going to give you some strategies on how to identify leave abuse and what to do when you identify it, and that will lead us then into our third and fourth risk, which is work climate and investigations. So here are the top 10 thorny issues that can prick you if you're not careful. Incomplete or ambiguous medical certifications. If you don't try to get clarity of the medical certification, then you are stuck with those ambiguities in a way that may come back to be a problem on the back end in trying to establish that it was leave misuse, that it was an exaggeration or a fabrication, because the employee may avail themselves of those ambiguities in a way that doesn't give you solid footing. CFRA limits contacting healthcare providers beyond authentication. You can't write to them, you can't, if they give you a CFRA authentication that is complete, all you can do is ask them if you have some questions as to whether it's legit. If you have objective reasons to question the validity of the certification, you can do one of two things. You can either do a second opinion process, which is cumbersome, or you can do an authentication, send something to the doctor's office or the healthcare provider's office, asking them if in fact that came from their office. I have had leave abuse issues in my years of doing this hotline, and I had one for a school district years and years ago where the employee used some software to generate a replica of the certification form. And how did we catch her? And it didn't come from the doctor's office at all. How did we catch her? We caught her because we looked at who transmitted by, this is how old this is, who transmitted by fax the certification form, and it was from a FedEx Kinko's. Now, I don't know about you, but I don't know any doctors who send their certification forms by fax from FedEx Kinko's. And the letterhead looked a little odd. So we did the client, the district, and I worked together on a misconduct investigation. When we finally came to interviewing the employee, she said, well, her husband picked it up from the doctor's office, took it to FedEx Kinko's to fax it to the district. So we did an authentication form, which was very easy to do, to the doctor's office. And the doctor said, no, we never saw this form. This is not our signature. Looks like our signature, but it's not. It's fabricated. And so then that was through a misconduct investigation. You can't just assume in the leave process that it's fraudulent or there's leave misuse. You do an investigation. Limitations on second and third opinions without good objective reason. We have to have a good objective factual reason to question the validity of the certification, and then we can go through that process. Limitations on requiring medical verifications for absences after the leave is approved. We need to distinguish here between job protected leave and other paid leaves. Your union contracts will control in most situations as to when you can ask for a medical verification. When you have somebody who is approved as intermittent leave, you can't ask for medical verification every time they take an intermittent leave day or a couple of consecutive intermittent leave days or a whole week of intermittent leave. You can't, once the leave is approved on the front end, there is no asking for medical documentation each time the employee uses their authorized intermittent leave. That's part of the law that we just have to live with. And so if that's the case, you want to go when you're applying the paid leave concurrently is when you look at your contract or your policies. The contracts, the Ed Code doesn't really provide anything specific as to what kind of note you can get from the doctor when they're absent 3 or more consecutive days. If you are applying paid leave and the intermittent leave hasn't been authorized, then you can ask for medical verification. But with intermittent leave, you got to be real careful. You will draw a leave interference claim within 48 hours if somebody asks for verification of that they've gone to the doctor. Most intermittent leave, the employee doesn't have to go to the doctor because they know how to take care of themselves. They either have to rest, or they have headaches, or they have episodic flare-ups. Do not mean they have to go to the doctor each and every time. You need to be aware of that, both for themselves and their intermittent leave for their caregiver. Medical notes that say telephone encounter, patient unable to work on X dates. We have to live with that now too, not just because of COVID, but because most healthcare providers do not want patients coming into the office, so they do a telephone encounter. We can't question that as being fraudulent unless we have other objective reasons to question the validity of it. And most of the time, those objective reasons are going to be observations of the employee in situations that would be reasonable to the reasonable person, objectively inconsistent with their leave. But we have to be real careful about that, and we're going to address that in a minute. Different documentation requirements for FMLA and the Ed Code. You want to be careful to do the right thing at the right time. A transition from one fiscal year to the next. I just talked to a district the other day, not an SIA district, where they had a certificated employee, and certificated employees only get one set of subdifferential for the lifetime of their career for the same condition, but if they have different conditions, they get new ones each time. They had an employee who last year, she had 72 days left on her original 100 days, and then she got another 100 days for another condition, and they gave it all to her in the same year, which is really not, they're only entitled to a maximum in the same fiscal year. Then they would be on unpaid leave until the next year. So we want to be very, very careful about those transitions from one fiscal year to the next. Performance problems that are close in time to the FMLA request. Does it happen? Sure it does. Supervisors think it happens all the time. It doesn't happen all the time, but does it happen? Yes. And is that leave abuse? Maybe. But we need to have, when I say maybe, it's because people who are having performance problems and who are about to be disciplined, that is very stressful. And it can be legitimately stressful. They wouldn't get a workers' comp claim out of it because it's an outgrowth of no matter how much their genuine stress is, it's an outgrowth of a good faith personnel action. But for medical leave, with as broad as mental health conditions are, you can have somebody with performance problems who is freaked out by their, to lack of a better word, who is very upset about their performance problems, and it's a legitimate leave. Is it stemming from the performance problems? Yes. Where it would not be legitimate is if they were just trying to delay the inevitable and getting somebody to write them a note or staying off leave when they're not really unwell at all. Do we have those? Sometimes we do. How do we deal with them? We do leave misuse or leave abuse misconduct investigations. Savvy employees who are threatening litigation for any adverse actions during or after the leave. That can be perceived as retaliation if we don't have our facts in line. So how do we get our facts in line? We do it by making sure that we've got objective observations and proper investigation procedures. So what constitutes intentional, what constitutes fraud or abuse? Intentional, deliberate, or knowing representations or concealment. Not accidental, not careless, not unwitting, not dumb, but intentional, willful, deliberate, not being too lazy or modestly ill to work, deliberately fabricating or exaggerating. It involves lying, deception, or concealment. People who just push the envelope and, well, they don't really feel all that sick, but it's easier to stay home and use their paid leave. That's not leave. That's not fraud or abuse. That's taking advantage of the system. There may be some things we can do about that, but leave abuse or fraud is not one of them. There are two types of FMLA fraud. One is using legitimate authorized FMLA leave for improper purposes, and the other is misrepresenting a serious medical condition. We see both of these, and we handle them in misconduct investigations. There are some FMLA leaves, and I have to spend a few moments on this. There are some FMLA CFRA leaves that are legitimate, that are not fraud and abuse, despite objective indicators, or what seem like objective indicators otherwise. What are those? Those are when the employee has a serious health condition that may not, but they may not be immobile or incapacitated. Often these are mental health conditions as opposed to physical. Think of it this way. If you have somebody who's on leave, and nobody's really supposed to know whether it's a physical or a mental health condition, but they're on a leave and their coworkers and their supervisors are not real thrilled with that to begin with. And now somebody sees them out and about in the community doing regular everyday things. They're taking their kids to school, they're going to back to school night, they're going to the cleaners, maybe they're even going to the movies and dinner when, when we didn't have COVID restrictions, and they were out and about in the community. We have had supervisors and managers, well-meaning, and administrators saying they can't really be incapacitated because look, they're out and about in the community. And here's what mental health care providers say. We don't want our patients, your employees, who may have a mood disorder, who may have a condition, whether it's physical or it's mental health, that is where they are tempted to just lie in bed every day or tempted to lie on the couch every day. We don't want them doing that. We want them out and about as part of their treatment, doing regular everyday things. Can they come to work with the stressors of work and the interactions and the structured requirements of that? Maybe they can't come to work. They're incapacitated from work, but they're not incapacitated from regular everyday things. And in fact, we encourage them to do those regular everyday things. So it isn't enough to say, well, I saw so-and-so at the cleaners or at the bakery or out with her or his family for dinner. That's not enough to be leave abuse or even to trigger an investigation. It might be a serious health condition that doesn't require bed or home confinement. Caring for a close family member who's seriously ill. They may have somebody who can stay with them in the evening to give the daytime caregiver a break. We have employees who have to do the daytime caregiving. Somebody else can do the nighttime. You can't say to your employee, if they're otherwise got a legitimate leave, well, you take the nighttime and let somebody else do the daytime so that you can come to work. So we have those kinds of issues as well. Now, you don't have to take my word for it. Take the California Supreme Court's word for it. This case, Lonneke versus Sutter Health Systems, is not a new case. It's got to be at least 6 years old, but it has never been overturned. And it makes the case more clearly than I could articulate. It makes the point more clearly than I could articulate. What happened with Ms. Lonneke? She had two jobs, two regular jobs that she had. She worked for Sutter Health Systems during the day, 5 days a week, and she worked for, I don't remember if it was Kaiser or who it was. She worked for another organization on Saturdays. She had an extra job on Saturdays, doing the same identical essential job functions. At Sutter, she did data entry, and the Saturday job, she did data entry for medical records and other things. She had a stress-related claim, not a workers' comp claim. She had a stress-related condition. Her healthcare provider put her on a 12-week CFRA leave. Sutter approved it based upon the documentation and their leave management practices. She continued to go to her Saturday job doing the same identical data entry. Somebody at some more than one, somebody's at Sutter said, whoa, wait a minute. If she can do the job on Saturdays there, she can do the job Monday through Friday in our workplace. Why is she on leave? This must be fraud. We never want to get from the whoa to the this must be fraud in a nanosecond. And that's what happened. So they did an investigation enough to, they didn't interview anybody. They did an investigation enough to determine that that in fact she was doing this, she had the same essential job functions, and she worked Saturdays at Kaiser, I think it was Kaiser, and they pulled her leave, and they said, this is, you misrepresented your leave status, and we're pulling your CFRA, and you have no job protected leave. Report to work Monday or you're fired. Now, talk about leave abuse. Well, she filed a lawsuit, and it went all the way up in the courts, all the way to the California Supreme Court, which takes quite a bit of a time. And the California Supreme Court, in a close ruling, 4-3, said the same thing that I told you on the prior slide, but you don't have to take my word for it. Take the California Supreme Court's version of it. When a serious health condition prevents an employee from doing an assigned position's tasks, this doesn't necessarily indicate that the employee is incapable of doing a similar job for another employer. Here's what made the difference in the court's view based upon the evidence that was gathered when, not when Sutter did their investigation. If they gathered that information when they did their investigation, we wouldn't be talking about this case and we'd be moving on to our third point here. They didn't do the investigation until the lawsuit was filed, at which point the pretrial discovery went on its merry way. Those of you who know anything about pretrial discovery, you know it's, if anything, it's comprehensive. It's not a workplace investigation, but it gathers facts. And the facts that were gathered were that the day job she had was a high volume, deadline-driven workplace where she was constantly under the gun for getting the work processed and constant interruptions and needing to multitask and lots of noise and congestion and all the things that can create stressors in a workplace. And her healthcare provider said that her stress-related condition was related to that day job. Now, take a look at the Saturday job. She's the only one or two of them in the office at the same time, and they have a body of work that's left on their desk for their Saturday, and they get it done in whatever time it takes them to get it done, and nobody interrupts them, and no multitasking, and no phones ringing, and no lot of noise. Was it the same technical tasks, the same typing and doing that? Yes. Was it a materially different workplace? Well, the California Supreme Court said it was. And the lesson here is the employer jumped to the conclusion that it was leave misuse or fraud and took the action that resulted in liability before they engaged their liability meter prematurely before they did their investigation. So that's an old case, but it makes the point pretty well, I think. Whether we can agree with it or not. I'm not here to change your mind on whether you think the law is crazy. Some people do. And I might under some circumstances, but we need to understand what it is. So investigation to support an honest belief that leave is abuse or fraudulent. You have to have clearly defined attendance policy and address notification protocols in the leave designation letter. Now we're back to, did we do the process on the front end that allows us to identify fraud accurately or misuse accurately on the back end? Enforce the policy consistently, interview witnesses and other employees, use a reputable surveillance company if you're going to use surveillance, present your findings to the employee and give them an opportunity to explain, by all means, please, and then process, and document your process. If you're going to terminate anybody for defrauding, you really have to have the goods, or you're not going to get past your termination. Won't stick through a skelly due process hearing. So that's what we need to do. So there are strategies for meeting your burden of proof, and that's a full investigation. Talk to the employee to confirm whether the outside work really exceeded the doctor's note. Compare the essential functions of the outside job with the employee's position in your organization. Contact the doctor for purposes of, now we're not talking about verifying the certification here. We're way past that. We're talking about a misuse. You've got enough evidence to do, enough indicators, actual objective indicators to trigger a misconduct investigation. You can interview the doctor and their staff in the misconduct investigation in a way that you could not just to authenticate the certification. You have to be careful about patient-doctor privilege, but there are ways to deal with that. You want to be careful when addressing an employee's activities while on leave, and here are two other cases that you should be aware of. Neither one of them are brand new, but they are relevant. Ballard versus Chicago Park District. This was not the California Chicago Park District. This is another Chicago Park, elsewhere. The court ruled that the employee who was on leave to care for her mother with end-stage heart failure didn't abuse her FMLA by accompanying her mother to a Make-A-Wish trip in Las Vegas. It was on her mother's bucket list. Her mother was clearly going to perish. She went with her mother. Her mother, in order to fulfill her bucket list trip, had to have a caregiver with her to help her with her activities of daily living. The court said, oh, come on, it doesn't make a difference whether that caregiver is doing the job in the mother's living room or in the hotel room in Las Vegas. It was clearly, the trip was approved by the mother's doctor only if the caregiver, which was her daughter, who was the employee, could go with her. So let's not jump to conclusions as the Chicago Park District did and ended up with a leave interference claim. Escriba versus Foster Poultry Farms, that's Ninth Circuit, so that is relevant in California. The employee has a right to decline FMLA leave to care for a parent overseas and use vacation instead. If they want to use vacation, they can use their vacation, and you do not have to force them. Not only do you not have to, you cannot force them to use their FMLA. That's on caregiver leave. For employees' own serious health condition, you can. So here are some signs of potential abuse that requires investigation and not an immediate reaction. Frequent requests immediately after a weekend or a holiday. Be on alert of that. That's a pattern that is questionable. Do by all means question. We want to nip leave abuse and misuse in the bud, but we want to do it in a way that's defensible. Request for sick leave after denial of vacation. So the employee applies for vacation, that's discretionary. The vacation is denied because it's not a good time for business. And then the employee suddenly is sick during the same time they were going to take their vacation. Okay, we're getting now to some suspiciousness enough to take a look at it. Calling in sick the same days as the denied vacation, sudden or abrupt leave requests that are not supported by any kind of documentation, but the caveat is make sure you're following your policies and your contract on what you can ask for in documentation. And with pre-approved intermittent leave, you really can't ask for it with each use. If they start using a lot of leave that was not part of the original designation, if the original expectation of episodics were once a week and they're taking it 3 times a week, that's a question mark. We can go back and take a look at that and get some further investigation going on that. Coworker reports specific, objective, credible, and verifiable information. Not suspicion, not subjective, not, oh, gee, they were out to dinner, unless the out to dinner was at a some kind of wedding reception or event out of state that looked like it was an incredible party that was inconsistent. And usually we will see those on Facebook. It constantly amazes me that people will engage in leave misuse or exaggeration or fabrication, and they'll take the leave and then they post their pictures on Facebook as if nobody is going to discover it. It always amazes me. Let me say, I told you I wouldn't talk about COVID much, but let me say a word about COVID. Some of the SB 95 leaves we have serious questions about. People who, I had one the other day from a non-school district client where the employee asked for 2 days off for vaccine side effects, and it was 4 weeks after the second dose of the vaccine. Well, nobody has side effects at that point. Sometimes the employees are so clueless that they're going to get caught, that those are the ones that are low-hanging fruit. The employee engages in seriously inconsistent social activities, suspicious activities that are inconsistent with the certification. These are potential signs of abuse. We don't ignore them, but we do the process. Authenticate the medical verification or certification. If you have a good faith reason to object, to doubt the validity of the certification, you can get a second or a third opinion. I put in your materials a sample validity of the certification form that we use to get the doctor to confirm. And I will tell you, Kaiser is pretty good about it. They don't like it when their patients are loose with the facts and falsifying their ginning up a note that looks like it comes from Kaiser and it doesn't. They will tell us. If we go through this process, they will tell us. I've had several of them. Surveillance can help, but it isn't foolproof. It isn't foolproof by any means. And here are a couple of cases. Vail versus Raybestos products. The person had migraines during the summer when her spouse's lawn mowing business was the busiest. She used 33 days from May to September. Raybestos hired an off-duty police officer who taped her mowing the lawn. The result was that her argument that she was never scheduled to work during the day, but only the night shift didn't carry any weight with the jury. Jury ruled against her and it was upheld on appeal. So that was where surveillance helped. Nelson versus Oshkosh Truck Company, it didn't help because the investigator found the person shopping, visiting her child's daycare, and doing things that were, maybe inconsistent with her restrictions, but not enough by itself. Might it have triggered further investigation before they took the action? Maybe. So surveillance can help by all means. So here's a checklist for you for addressing intermittent leave issues carefully so that you can deal with fraud and abuse on the misuse on the back end. If you have an incomplete or insufficient certification, don't blow it off and say, oh, well, there's a couple of boxes not checked off. I'm too busy for this. We're too busy for this. Nothing will ever happen with this, and file it away. Don't do that. Check off every box. If the certification is not complete, send it back to get it complete. Make sure that you authenticate and clarify anything that is inconsistent or objectively questionable on the certification form at the time you get it. There's no substitute for doing it on the front end, because then on the back end, it makes it much easier to determine whether it was in fact fabricated or exaggerated. Talk to the employee this is a repeat slide, I apologize. Actually, I got a couple of complete. I am really sorry for this. We have some duplicate slides here. I'm sorry. I was trying to get this done so fast that I had some duplicate slides here. Yeah. Investigation to support the honest belief defense. We talked about that. So here are a dozen strategies for preventing abuse. Obtain complete certifications for all serious health conditions. Examine them for signs of inconsistency or tampering on the front end, not the back end. Ask the provider to verify that the certification is exactly as they did it, or that it was done under their direction. Identify and follow up on signs of alterations or tampering. Require a second opinion, and once it's approved, make limited inquiry each time it's extended. Monitor the pattern of intermittent leave to make sure it's not inconsistent, a lot of Mondays and Fridays or days after holidays that's inconsistent with the certification. Request that the need for intermittent leave be recertified as the law allows. Require paid leave to run concurrently. Inquire about the intended method of transportation if the employee leaves early. If they leave early, how are they getting home? Particularly if they say they've got a really bad headache or they're really sick. How'd they get home? How'd they get to work that day? There are things that you can ask. Maintain process integrity and always enforce your policy consistently. So now we are on to work climate. We're going to pick up the pace a little bit. Harassment, bullying, and abusive conduct. Remember that there are 7 R's of risk prevention. Respect for individual differences and individual comfort levels. Recognize harassment or abusive conduct when you see it. Refrain from it yourself. Report it if you have seen it. Respond appropriately. Make appropriate remedies and maintain harassment-free, retaliation-free work environments moving forward. Try to avoid and make sure that you train your frontline leaders to avoid hasty and ill-considered email that breeds conflict. This is what breeds bullying. Email. Don't be e-nailed in the courtroom by your supervisor's email. Is this still an issue? Yeah, it sure is. We still see email being, it's the first thing that the opposing parties ask for in discovery. Why? Why do they want to see the superintendent's email? Why do they want to see everybody's email? Because usually there's something in it that they can find, that they can um, exploit in a way, particularly if it's ambiguous. Increased bullying and incivility complaints are often called hostile environment. They can be yelling, persistent derogatory statements, exclusions, isolation. This is just a little checklist for you. Exaggerated body movements and eye rolling. We're seeing, I can't get away from the COVID topic no matter how hard I try. We're seeing a lot of it with the mask issues and the vaccination issues. And if we go back, if the CDPH follows the CDC's guidance from this morning saying that fully vaccinated people should wear face coverings indoors, the fully vaccinated people who have in a short time become very happy with not having to wear face coverings and who may have to wear them again may not be particularly happy about it. And we don't know whether they will take it out on other people or whether other people will take it out on them, but we need to be aware of that. There are differences between harassment and bullying, and the column on the left is harassment, the column on the right is bullying. Both are unlawful, both require an immediate investigation, both require do's and don'ts from your district leaders. They need to be alert to spot it, take it seriously, report it to HR. It's required by California law to report if they see behavior going on, even if nobody's complained yet. They have to cooperate in internal investigations. They should not assume individuals are too sensitive or lying. Don't convey disrespect or intolerance. Don't refuse to report a complaint because you think it's silly or overstated or overreaction or overly sensitive, and never retaliate. So what are our lessons learned from the hotline trenches that can explode in the courtroom? Employees who complain about jokes that most people think are funny, they're called overly sensitive, they're told they need to adapt to the work culture. Employees with performance problems raise hostile environment claims. They need to, in order to shield themselves from poor evaluations. That's a myth. These are myths. These are things that supervisors say out loud or in email. Administrators say it. Sometimes HR people say it. Always, if it gets into evidence in a courtroom, it's not a happy circumstance. Witnesses lie or exaggerate to get supervisors in trouble. Does that happen? Sure. Does it happen often? Not nearly as often as people think it does. Misconduct investigations are a waste of time without direct evidence. Wrong. We always do misconduct investigations. An employee who reports discrimination can't ever be disciplined because of the non-retaliation laws. That's not true. We can discipline if we have a reason for it, but we do have to remember that retaliation claims are rampant. And we want to be very careful to avoid the common forms of retaliation that stem from reprisals from protected activity or oppositional activity, including making complaints about or reports about concerns about safety protocols not being followed. We want to be very careful to avoid retaliation claims by some of these reactions to individuals' complaints in the context of harassment and bullying. This is a proactive prevention strategies for you. There are 10 steps to recognize how to prevent and be proactive about preventing interpersonal work climate conflict that isn't handled properly by process. And if it isn't handled properly, then it can lead to litigation. So what triggers a duty to investigate? Well, you can get a report or a complaint. You can get a demand letter from counsel. You can get people raising safety issues or whistleblowers, all sorts of ways that individuals will make a complaint or report that needs to be investigated. It can be written, it can be verbal, it can be the supervisor reporting what they've seen or heard. It can be a statement in an exit interview, and you can't say, woo, dodge that bullet because the alleged victim is leaving, and in the exit interview, they tell you about harassment and bullying. You've got the alleged harasser or bullier still there. Offhand comments from employees that are directly made to the employee or made by the employee or overheard by the supervisor. I remember a case years ago of an employee who was talking to another employee in the ladies' room, and they didn't know the supervisor was in there. She wasn't visible. And she heard them talking about a very harassing situation. Neither one of the people who were talking about it made a complaint. The supervisor overheard it. They didn't make a complaint to her. She didn't do anything about it because she didn't think she had to. And lo and behold, 6 months later, somebody else made a complaint about the same harasser. And they called the supervisor in to see what she knew about it. And she said, oh, gee, I heard, Joan and Jane in the ladies' room talking about this. I wish I'd done something then. If I had done something then, maybe we wouldn't be here now. When supervisors overhear these things, they have to report them. It may be something, it may be nothing. It may be substantiated, it may not be substantiated. But offhand comments need to be addressed if they are objective and specific. If I had time, I would go through in a little more detail on this slide of you be the judge, but I'm just going to tell you what this was about. This was a high school principal who reported to the school board president that the then superintendent was sexually harassing her and other employees. She made her report to the board president, she said, not only on her own behalf as a victim of the prior superintendent's alleged sexual harassment, but also on behalf of the female employees in her school. The board president said, and this is a direct quote, "I've been friends with the superintendent for many years." Okay, does that tell you it's going to be investigated? No. Did the principal feel like she had anywhere else to go? Because she couldn't go to the superintendent who was the alleged harasser. She went to the board, which was the place that she would go. I guess she didn't feel that the HR people would handle it appropriately because it was the alleged acts of the superintendent. So she went to the board. The board president buried it. Eventually they started to do an investigation because more people made a complaint about the then superintendent. That superintendent officially retired. Before the new superintendent started, the new superintendent made critical remarks about the principal's management of graduation. It came out in the trial that he knew that she had complained about the prior superintendent. He was either trying to be prophylactic to not get a complaint himself, although if he hadn't sexually harassed, I don't know why he would have worried about it. But it was either that or he was also a golfing buddy of the prior superintendent and the board president. So together, the board president and the new superintendent retaliated against the principal by moving her back to the classroom without a lot of objective reason to do that. She sued for retaliation, and hold on to your seats, folks. This was Young versus Mountain Empire Unified School District way back in 2013. $589,645. Why? Not for the alleged underlying sexual harassment. That was old news. Almost $590,000 for failing to do an investigation and to take appropriate corrective action if it was warranted. $150,000 in emotional distress. Okay. $439,000, almost $440,000 in attorney's fees. Here's what you need to remember about attorney's fees under the California Fair Employment and Housing Act. If the employee makes 4 allegations and they win on only one, they've won on only 25% of their substantive allegations. And if they ask for, $500,000 and they win $50,000, they've won a fraction of what they asked for. And they get 100% of their reasonable attorney's fees. And if the district is defending or the county office and you win, what do you get in your attorney's fees? 0, unless the case was totally fabricated or there was a hidden agenda, fabricated or lying or a misuse of process. And most of these cases are intent driven, so who's to know whether it was fabricated or not? So that's an important lesson on the importance of investigation and the importance of avoiding lapses in the investigation process. So this top risk number 4 is all about the investigation process. And since I'm going to be short on time, I'm just going to tell you what is the remainder in your materials. And I promise you that we will do whole webinars. I'll work with the SIA team to determine what dates we do in the months coming ahead on how to do investigations and how to do discipline and due process, which are the remainders of our material. So indulge me for another 5 minutes or so I can tell you what's left in your materials here and get you on your way for today. There are these are self-contained slides, so you can use them for whatever your purposes are. They at least give you an overview of the fourth and fifth big risks that we see in the start of the new year. Complaint procedure that has lapses in it. A complaint procedure that is incomplete. A complaint procedure that is biased, not necessarily deliberately ageist or sexist or racist or anything like that, but biased because the investigator is not completely neutral. HR could not investigate the superintendent. There would have to be an outside investigator. Not because the HR people would fudge or make excuses for the superintendent or for the employee, but because you can't be totally neutral if you're investigating your boss. The same thing is true if it was somebody in HR and there were to be an investigation, or a principal. Principal can't investigate him or herself, nor can they investigate others who directly report to them, at least not easily. So an investigation that is not entirely neutral is a lapse in policy. You want to take steps to avoid retaliation before, during, and after the investigation process. You want to know that California Fair Employment and Housing Act, FEHA, imposes a separate duty to conduct a sufficient investigation, and the duty, just like the duty to engage in a timely, good faith, individualized interactive process violates the law, even if it turns out there's no reasonable accommodation. Remember that? You have to do an interactive process. It has to be timely, individualized, and good faith. If you don't do an interactive process, even if it turns out that there was no accommodation, you still have a liability for failure of process. It's the same thing here. If you don't do an investigation and then you have violated the law, even if it turns out that it wouldn't have been substantiated if you had done the investigation. These are twin requirements of California law. You must remember that you are living, working, and risk managing in the independent nation of California. And the failure of process is itself a violation of the law, even if the process would have led to no action required by the employer. No reasonable accommodation if it's an interactive process, no corrective action if it's an alleged harassment. Keep that in mind. Process, process, process. The three most common and costly grounds for failure to prevent claims are the absence of policies. We'll help you with your policies if you need updated investigation policies, inconsistent or ineffective enforcement of the policies you do have. That's almost worse than not having a policy, is having one and then not enforcing it. Inappropriate reactions to a complaint. Oh, you're overly sensitive, you're unreasonable, you misunderstood. Why in the world? I don't want to replace your own sexual harassment training, but if you've had sexual harassment training, you know that they tell you have to have multiple avenues for complaint so the person feels comfortable coming forward and making it known. Why would people not want to come forward? Because sometimes the reaction is worse than the original stuff. And if they're fearful that the reaction is going to be, oh, come on, you're overly sensitive, you're unreasonable, it was just a joke, what's the matter with you? Why don't you have any sense of humor? If the reaction is that way, they're not going to complain about the underlying behavior because the reaction is worse and the reaction is retaliatory, at least. Elements of an effective investigation is a little checklist for you. Potential legal challenges to how the investigation is conducted. Failure to conduct any investigation, untimely or delayed investigation, which was part of the Mountain Empire situation. Biased or incomplete, lack of effective avenues for complaint. Don't give people proper ways to do it. Claims by employees can range from invasion of privacy to defamation, which is rarely successful. No due process. If you didn't interview the alleged offender, you have a due process issue, potentially. Bias on the part of the investigator. That doesn't mean ill intent. That just means lack of neutrality. There are three parts to an investigation. Did it happen or didn't it? Is it inappropriate behavior or isn't it? And what are we going to do to stop it and correct it? Remember that corrective action is not for the purpose of discipline. It's not for the purpose of punishment. It may be discipline and it may be punishing, but it is not for the purpose of punishment. It is for the purpose of correction. I use this analogy a lot. If you have teenagers at home and you have a teenager who abuses your car privileges, the parent's car, teenager takes it out, gets a DUI, gets into a fender bender. Are you inclined to, are you mad? Sure. Do you want to make the teenager hurt? Maybe. Do you terminate the teenager or discipline the teenager more harshly than you need to? Well, probably not. It's the same thing here. Your employees are not adolescents. They are not teenagers. They are adults in the workplace and they are accountable for their own behavior. But the purpose of corrective action is to stop the behavior and prevent it from happening again. It is not for the purpose of disciplinary action. It's not for the purpose of punishment. The law doesn't exist. The law exists only to compensate and punish if it gets into a courtroom situation. The law is you take corrective action to prevent it from getting in a courtroom. It's not for the purpose of punishment. We don't have to compensate anybody with damages. It's for the purpose of correction. So you inquire into the facts, you take appropriate informal fact finding, and you do a formal investigation. Remember that nothing is off the record, nothing is anonymous. Do's and don'ts for leaders during the investigation process. I think this is a repeat from the section that we did on leave abuse, but the same things apply. Misconduct investigations that lead to disciplinary actions. These are all the kinds of things. We've talked about leave abuse and bullying and abusive conduct, but we also have the plain old-fashioned stuff: lying, dishonesty, dealing drugs in the parking lot, confidentiality breaches, lapses in judgment or integrity, violence or threats of violence, attendance irregularities that are not subject to leave abuse issues. Those are the kinds of things that will allow you to do an investigation with electronic evidence and the means to determine did it happen or didn't it? Is it inappropriate or isn't it? And what are we going to do to stop it? Don't forget about plain old-fashioned electronic communications, because loose fingers produce zingers and they lead to lawsuit stingers. So this is a little checklist for you on making sure that people always remember that email is discoverable. The only email that is not discoverable is what you send to your lawyer asking for legal advice, or what your lawyer sends back to you. It's the only thing that's not discoverable. In a civil lawsuit, there may be some things that don't have to be, that are personnel related, that do not have to be disclosed with a Public Records Act search. But in litigation, the standard for relevance is anything that is relevant to the subject matter of the litigation or calculated to lead to the discovery of admissible evidence. I'm a recovering litigator. I haven't litigated in 15, 16, 18 years, something like that. But those are words I will never forget. Calculated to lead to the discovery of admissible evidence. Who were the witnesses? Who received the email? Who sent the email? Who got a CC on the email? Half the time in the old days, we had people who were over CC'd, and they'd get in to have their deposition taken, and they'd say, I don't know anything about this. And it was a waste of time and money. And sometimes they knew something about it that was not helpful in the litigation. The facts are whatever they are. Sometimes they help, sometimes they don't. Let's make sure that our documentation is right and tight, and that we dispel the reasonable expectation of privacy that employees might think they have in their email, because these are all subject to discovery. Now, I am out of time and I do not want to abuse my time with you. So let me tell you that the last section of your materials deals with discipline and due process. I have a whole webinar that's a 90-minute webinar that we would do on discipline and due process, distinguishing between performance and disciplinary action, talking about the causes of distorted discipline that can lead to lawsuits, all of the things that involve discipline and due process. Let me leave you with this. I opened by saying the word COVID was not going to be uttered by me too much today, but I can't leave you without this. We're now seeing, we'll cover a lot of COVID issues 2 weeks from today. One of the things we will cover at that time is the potential for disciplinary action and how to do it. And we will cover that in depth. I won't save that to the end when I run out of time. We are finding that organizations are having considerable difficulty right now enforcing the mask mandate, even in the non-school environment for unvaccinated people, getting unvaccinated people to consistently wear their face covering. If they are violating directives and absolutely refusing, we now have entities that are taking disciplinary action for insubordination. I had to tell one of my clients this morning that was not a school district that, in my opinion, what they had to do in the situation that was in front of them was a version of discipline of the supervisor. Why? Because the employees weren't wearing their face coverings. Their reason for not wearing them is nobody was reminding them about it. Now, should they have remembered? Certainly. Their response was, I didn't get a directive that I had to. I was told, sure, here's the policy. And my supervisor just kind of closed eyes, closed ears, didn't do anything about it. And it turned out that that may be accurate. After a misconduct investigation or any kind of investigation, if the administrator or the supervisor's attitude towards face coverings is, I don't want to enforce them, at the line level, at the supervisor level, that in the workplace, not students, in the workplace, that may be subject to discipline, but you have to do it right. They have to be given a directive by somebody, either immediate supervisor or HR or somebody, that they are to enforce the face covering consistently. And if they don't, they may have to be disciplined for not enforcing, as opposed to disciplining the employees for not wearing the face covering. That's one issue we're going to be addressing in the weeks to come. If we go back to everybody having to wear face coverings, I don't think we're going to have the same problems, because everybody has to wear them. And the unvaccinated won't be able to hide behind the current standards. The other thing that we have to discipline for, sooner rather than later, in real time, is work climate process issues related to masks, related to vaccinations, related to all those things. And the other thing is, the last thing that I'm not prepared to give you a lot of direction today, but I will be 2 weeks from now. What do we do when we find objective, just like we have people who fudge a little bit on their, or maybe more than a little bit, on their leave, they exaggerate or fabricate, and we've got leave misuse, or we've got leave abuse. Okay, that's one thing. What do? We investigate it. We have a process to address it without getting into running afoul of the leave abuse, leave interference laws. Now, what about somebody who self-attests, and it has that language, we hope you have at the bottom of your self-attestation. You are being authorized based upon your representations, you are being authorized not to wear a face covering if you're fully vaccinated. You must be truthful. We reserve the right to ask for the documentation. We are finding some places where there are objective indicators that people have been less than forthright on their self-attestations of fully vaccinated status. Do we need to consider potential corrective action? Yes, we do. What kind of corrective action is appropriate? We will leave that to 2 weeks from today to give you some direction. I can tell you that it would be in this area of disciplinary action. No, we do not want to be spending our time doing a lot of discipline of people over face masks and vaccinations and other things. We don't. We want the kids to come back to school and be safe. We want the staff to be safe. We want everybody to be educated and managing and not worrying about all this discipline and misconduct investigations. But the only way we're going to make that work is if we have the means and the will and the process to address it in the appropriate way if we have to. So it's going to mean you have to have enforcement policies that are in effect and that are clear and unambiguous, and then we have to follow up. Because if we ignore it, sooner or later we'll have chaos and everybody will be violating the rules. And then what happens is they do this. Well, Sam did it and you didn't discipline him, but Sally did it and you immediately disciplined her. What's the difference between us? Oh, gee, it must be my gender or my fill in the blank, So with that, I'm going to let you go. There is additional material in here on memos of concern and warnings about retaliation and due process in public employment, all about due process. It's not a very long section. If you have questions about it, here's what you can do. You have a supervisor's frontline, supervisor's checklist for discipline. And then you have my email address and my direct line number. If you have any questions whatsoever about what I've covered too fast here today, or what I skipped over because or didn't explain clearly, or something that I didn't address at all and wasn't expecting to, or something that I didn't get to, or anything else on your plate. If you have any of those questions, this is what your hotline is for. We're here for you, and you have unlimited access. Every one of our SIA and STSIG members have unlimited access to the hotline. Those who use it all the time. Those who haven't yet used it, please contact us, reach out, and we'll do whatever we can to assist you. Thank you for your attention. I'm sorry I did go over a tiny bit, not as much as last time. I'm getting there. I'm getting closer to my 90 minutes, but I appreciate that people stayed, and I will look forward to seeing you 2 weeks from today, and we will send you a description of what we're going to cover on anything updated that is important in the area of COVID protocols and procedures as we start the school year. Thank you for your attention. Jennifer, did we have any other questions?
No, I just want to thank you and tell you that we appreciate you so much for all of this
Okay.
information, and that we look forward to what you can share in the future about investigating properly and about
Yes,
the due
I will do a whole
process.
webinar on actual investigation techniques with how to do questioning of witnesses, how to write reports, how to assess credibility. Today we were just covering, where are our process lapses. But yes,
Right.
I will do that. I'll have a whole webinar on it that we can offer if you want us to, and a whole webinar on discipline and due process. How to
Yeah,
write
talk
notices
about
of
that.
intent, how to write memos of concern, how to gather the facts, way beyond frisk. I mean, yes, we'll talk about frisk, which is a method of a documentation method, which is fine, but we have other processes as well.
Right. And I think that, yes, trying to capture those, like you say, the process is so important, and then the documentation. So anything that
Yeah.
we can get for that, I'm sure will be very helpful to our members. And people are just throwing into the chat, thank you. So
Okay.
I think we're all set.
Thank you very
If
much.
anybody
Have
has
a
any
good
more
day. I
questions.
apologize for those duplicate slides.
Oh,
They're in
no,
your
that's okay.
materials.
Not at all.
Okay. Thanks very much, and have a great day. And stay
Thank you. And
safe,
thanks
everybody.
everyone for
Stay
coming.
well,
And
please.
I'll let you all
Everybody be
know when
well.
the recording is available. I'll share that out. So we'll
Thank
start.